Hey everybody, welcome back to another month here at the Boston RIA Club, and this is for those of you listening at home, this is our meeting before the meeting, and this particular month we are going to be talking about earnest money deposits, and we're going to be talking about how to use other people's money to get your multifamily deal under contract. And this is a technique that we use with the owner forum members. This is a technique that we use with that I've helped other people use, and I'm going to take you through it step by step to make sure that if you want to do it on your own, this is how you do it. If you need protection, you need somebody to work with, we also provide that service at Dobbins Law and through the Multifamily Investing Academy as well. Now, I say that because I think I kind of invented this program. I know there's somebody out there on the internet who's now out there trying to do earnest money deposit loans, and he's new in the business. I've been doing this for years. Somebody stole this concept from me a little while back. Guy happened to be somebody that I was working with, and he liked the idea so much he went out and stole it. He did. He flat out took my contracts and went out and tried to make money lending earnest money deposit funds, but he didn't understand how the program worked. And I know he stole it from me because one time one of my clients used him to fund their deal, and they asked me to review the contracts. And so they sent the contracts to me and said, Charlie, what do you think about these contracts? Well, I think they're great contracts because I wrote them, but I don't understand why a lender in California who is lending money to a party in Virginia on a property in Georgia is citing Massachusetts as the choice of law and choice of forum in the contract. And my client says, "Oh, geez, I didn't even see that. Let me ask this guy in California, the guy who stole it from me." And they go and they said, "Oh, I'm sorry, that must just have been an oversight." And I said, "Yeah, real oversight. It's my contract. He's flat out stole it." So at the end, I'm actually providing a template of my contracts. And folks, I'm providing you with a template so you can see how the process works. But if you decide to do this on your own, please have a local attorney review your documents. Don't cut corners. LegalZoom loves litigation. Lawyers love litigation, and lawyers love LegalZoom because it creates litigation. So just cover yourself and make sure you look at these documents beforehand. Okay, so that is a little bit of the background on all of this. Let me talk to you about the process of buying multifamily property. I mean, I can honestly say getting to the closing table of a multifamily deal is a lot like running a steeplechase. You can do it right and you can look like a pro, and if you know how everything flows together, it'll be a nice, easy process to buy that property. Or if you don't know what you're doing, you could end up looking like this. And nobody wants to look like this because you can't even get over the first hurdle. You're never going to buy multifamily property. All right, it just is. Everybody, every step of the way, are always just trying to put roadblocks up in your path. As I always say, this is a hoop jumping business. And think about all the things you have to provide to get the deal done. Think about who are the people along the way that are putting up these roadblocks. Who's the first roadblock? Who's the first human speed bump? Who's the first human rain delay? The brokers. The broker's job is to whittle out and wean out those people that will not be able to get a deal done. So one of the first things they do is they ask for, "Excuse me, can you please provide us with a proof of funds letter so that I can make sure that you are who you say you are?" Like, oh, really? A proof of funds letter is going to determine whether I'm a qualified buyer or not? Sure. Let me jump on the internet and hit proof of funds and see what comes up. The other one is a real estate resume. How many times you get this line from a broker saying, like, yeah, listen, before we are going to accept a resume from you, what we're going to need to have from you is to see your real estate resume to make sure that you are who you say you are, but also that you can qualify to buy this property and that you are a multifamily owner operator. Now, right away, a new investor is going to cave. He's never going to get over that roadblock. He never will. Now take a look at what's another thing that people throw up. Obviously, we're here talking about it today. The earnest money deposit is a roadblock for people. I mean, if you have to put up a 1% earnest money deposit on a deal, and it's a $5 million deal, well, you better be able to write a check for $50,000. Can you do that? No, I can't. Well, guess what? You are not allowed to play with the big people in the multifamily arena. What's another thing that comes up? Obviously one of the biggest ones is the down payment. Well, okay, that's a tough one. That one you're going to have to really work hard to pull that one together, but it can be done. It can be done. I've done it a million times. Well, not a million times. I got to be careful about my absolutisms, but I've done it over and over again, folks, and most of my clients do the same thing, and you overcome this roadblock. All right. Another thing that comes up is a key principle. Like, you need to find someone who can qualify for the mortgage, someone who has a net worth equal to the value of the property, someone who's got liquidity equal to the down payment of the property, and somebody who's got a real estate resume that, property that they've owned and operated for years. Can you provide that for me, Mr. New Investor? Oh no, I can't do that. Well, guess what? You will never get into this business. Now just think about it, folks. If all of these roadblocks were always thrown up in everyone's face, who could ever overcome this? Who in their right mind, in the first time they've ever done a deal, could ever overcome these roadblocks? You can't do it. So what do? You create programs and systems and ways that we can overcome these objections, overcome these roadblocks. Just think about it. And I want you to think about this very clearly. If you can't overcome the very basic hurdle that a broker puts up in your face, then when you turn age 65, the only two sources of revenue you will have will be coming from the U.S. government. You won't have multifamily real estate to supplement your retirement. You won't have that passive income that's going to provide you funds for the rest of your life. You will have two sources of government income. Everyone knows what the first one is, Social Security. What's the second one? It's called your your can and bottle deposits. I saw a guy walking down the street, an old timer walking down the street with a bag full of cans. That's how he supplements his retirement income from another government source. Social Security and can deposit returns. Is that going to be you because a broker asked you for a proof of funds letter and you couldn't overcome that objection? Don't let that be you. Okay? So, all of these things, with a slight, the down payment, we help as much as we possibly can. But all of these roadblocks, the members of the owner forum can overcome. We have created ways to overcome these objections. All right? The first one is, the one that we're going to talk about here today, strictly, is the earnest money deposit. Holy cow, Charlie. Are you trying to tell me that I need to write a check for $25,000? I can't do that. So how can I overcome this? what way can this be done? Let me show you how we do it for our students and how you can do it on your own or you can do it with us as well. Okay, so let's take a look. Here's how we solve the problem. The first step is, before we get started, let me just kind of explain for many of you what is the earnest money deposit. Okay, the earnest money deposit shows that you are earnest about getting this deal done and you're willing to put some money up to make it happen. Now, different states have different earnest money deposit requirements. Now, remember, as an attorney, I'm telling you, hire an attorney, because for instance, there are, I think, 12 or 17 states that require independent consideration to make a contract valid. All right, so down in Texas, if you put up an earnest money deposit and you get to have it all back in the event that you quit, that's not a valid contract because it lacks independent consideration. So what those types of states that require that in real estate contracts, what they do is they say, okay, the earnest money is $25,000, but then we're going to have this little $100 over here. And if you quit this contract, you get your $25,000 back, but they get to keep the 100. That's the independent consideration. And so certain states require that to make it a binding contract. Make sure you know the rules in the states you're doing business in. So in this particular case, what we're talking about is the earnest money. The contract, the purchase and sale agreement says that if this, within a certain number of days after a certain event occurring, like the execution of the contract or the receipt of all of the due diligence material, the buyer will put a certain amount of money into an escrow account held by an escrow agent who will hold it like as the referee. And after a certain amount of time, like say 30 days, if the buyer decides he doesn't like this deal and he wants out, he gets his money back. But if the buyer decides to stay in the deal after that inspection period, then he goes into the financing period. This is typically how we write our contracts. Then he goes into the financing period. And in the financing period, his earnest money being held by the escrow agent is now conditionally hard, meaning if he doesn't get the financing, he gets out. He gets to have all his money back. All right, so that is how the earnest money deposit works. It is found in the purchase and sale agreement, and it is defined in the purchase and sale agreement as well. It has to be within the four corners of that contract, or the court's never going to look outside of that. Well, let me take that back. They would have to look outside the contract, but they're going to try to look within the four corners to make sure that everyone's doing everything correctly. Now, the big question is, when is the earnest money deposit due? Now, here's the thing: when you work with me, when you work in, and we start putting together the purchase and sale agreement for you, what we do is we define the effective date as the date that you receive all of the due diligence information from the contract, from the seller. That means that the seller has to get you all the items that we've asked for. And once he's given you all those items and everybody checks off on it, that becomes the effective date. And now from that date on, you go to the earnest money deposit definition and it will say something like within 3 days of the effective date, the seller has to put the money in with the escrow agent. So it's kind of a floating date because it isn't defined exactly. It is dependent upon when the seller gets all the information in. Now here's the rub, just so you understand this. From the very first piece of correspondence we ever send to the seller, the letter of intent, we list everything that we want right there in that agreement. Everything is right there. Okay, so now we've got the list. And once we get the deal under contract, they accept the LOI and we start negotiating the purchase and sale contract, that list becomes part of the contract. So now we're into 2 to 3 weeks of working with this particular seller where they know what we need. And then the day comes when we execute the contract. And we end up sitting back and waiting and waiting and waiting. and the seller's not getting us the information we asked for. Well, what we did to protect ourselves against that is we said, hey, listen, you're not getting us the information. We're not going to put our money up. We told you from day one, well, wait a minute. No, you've got to put your money up. Oh, you're absolutely right. We have to put our money up. But you have to do something before that event occurs. Well, I can't get you this information right away. Well, you know what? You should have told us that back when you agreed to our letter of intent. And now we're sitting around here with our hands on our fist, and had we written the contract the other way, you'd be burning through our inspection period, and we wouldn't have any documents to look at. So we have crafted the purchase and sale agreement so that the effective date is a floating date that is dependent upon when the seller gets us all the information. Okay? Understand how that works. So that is typically when the earnest money is due, a certain number of days after the effective date, which is that date when the seller has finally given us everything that we need. And that's when the earnest money deposit program triggers and gets started. Okay? So if you don't have it, if you don't have the earnest money, I mean, it can be a hurdle that prevents you from getting deals done and under contract. And you'll never be able to determine if you have a deal or not because you'll never even get through the due diligence phase. If you can't get a deal under contract, the seller's never going to give you the information to go through the due diligence phase to find out if you've really got a smoking hot deal. So you need access to earnest money in order to make this stuff happen. All right? Now, just let me assure you folks that I've done this before. I've been on both sides. I've been on the side of the person looking to get the deal under contract and having the earnest money available. I've been the person who had too many deals done, and or my tuition came due, and I didn't have the earnest money available. And then I have students who are like, geez, Charlie, I got this great deal, but I need, $30,000 for the earnest money. And I realized, crap, what do I do here? I know what it's like to be in that position, and I remember how I solved the problem. How can I solve this problem for my students so that they don't have this as an objection? And that's when I came up with what we call the solution of the problem, and came up with what I call the Earnest Money Deposit Program for the Multifamily Investing Academy. And just so you understand how it works, think about it this way. It's really the equivalent of hard money lending for the earnest money deposit. And you might be thinking to yourself, oh yeah, that makes total sense. Yeah, it does. But here's the problem. Hard money lending is easy because it's collateral-based lending on a piece of real property in first position. So what does that mean? That means that the guy who lends the money on hard money is lending a very low loan to value. He's in the first position if anything goes wrong, and it's on a hard asset that he can go look out his window, go touch and feel it, and he's protected. That's an easy loan to make. The earnest money deposit is different. You're lending, not even lending, you're working within partners where there has to be a level of trust and a level of understanding and a degree of knowledge on the contracts. And that is how the problems start for these people that don't understand the earnest money deposit program. Okay, so let's take a walk through it so you can see exactly what I'm talking about as to how this whole process works. Okay, the first thing that you have to do is obviously get a deal under contract. So you get a deal under contract. Now you need to have the earnest money lined up for when it says you have to pay it in that contract. Okay? The way it works is I am going to introduce to you, if you're in my program, or if you are doing this on your own, you need to have a partner who has the available cash funds and is willing to enter into a contract with you for that earnest money. Now, I call this person a partner, and I don't call it a loan, and I don't say that you're borrowing money, and I don't say that you're investing your money. You are partnering with a person. This guy becomes your partner. Because you see, what happens is, as soon as you find that partner, the next thing that has to happen is you take your purchase and sale agreement and you assign it to your partner. And he now owns that contract. And he is going to write a check to the escrow agent who is going to hold those funds in escrow per the terms of the purchase and sale agreement. Okay? Now, that might kind of scare you a little bit because you worked so hard to get this deal under contract. You worked so hard to find this deal. You finally got the deal under agreement. And now you just assigned it to somebody else? And you've just given up all rights, title, and interest to that contract to somebody else? How can you get your deal back? How do you get your money or your contract back if you decide you're going to buy this property? And the thing is, at the time that you assign it to him, he is going to execute a subsequent assignment agreement that assigns it back to you. Oh, well, that's easy, but how does all that work? Well, here's the catch. And this is the tricky part. And this is where you start to really need to understand the machinations of how this operates. That subsequent assignment gets held in trust, or it gets held in escrow by an attorney. Like with my clients, I hold that subsequent assignment. And I am told by both parties, there's another agreement between us and the parties that says, in the event that XYZ happens, then, Mr. Attorney, you need to release this assignment. Or in the event that this doesn't happen, then you need to do this other task. Now let me kind of give you a little bit more color as to how all of that works, all right? In other words, what are these conditions that have to occur? Let's map this out. Follow me on this, okay? The partner has the contract. The person who got the deal under contract, we'll say it's investor one. Investor one is still going to work with the partner, the earnest money deposit partner, and he is going to go out and do all the due diligence and do all the analysis during the inspection period, and he's going to make the decision whether this is a good deal or not. And if he says, I like this deal, I want this deal, I want to move forward with this deal, then he says to the earnest money deposit partner, okay, I have found other funds and I will replace your earnest money with these other funds because these people are going to be long-term investors with me. So, Mr. Earnest Money Deposit Partner, it was nice meeting you. I've really enjoyed our time together. And here is the $20,000 that I am going to replace of the Earnest Money Deposit funding. So in other words, while all the inspection was going on, the buyer of the property, investor one, is out there talking to his friends and lining up his private money and saying, okay, I'm going to get these deals, and I'm going to he's saying I'm going to go out there and I'm going to find money to replace yours and also money for my down payment. And once I have the funds lined up, I'm going to give the earnest money deposit partner his money back. Now, the escrow agent who's holding that subsequent assignment is looking and says, okay, give me the money, the $20,000. I'm going to give it back to the earnest money partner. And because one of the conditions, or the condition, is that the money has been returned, now it is my responsibility to execute and publish that subsequent assignment contract, which reverts the purchase and sale agreement back to investor one. And he is put back into his position. He's got the deal under contract. He's moving forward with it, and all the parties get what they need. All right? That's how it works. Now, what happens if before the end of the inspection period, the investor one says, I don't like this deal. This deal is bad. I'm getting out. Well, the escrow agent and the earnest money deposit partner and investor one have been talking all this time. They realize the deal's not going forward. We're going to terminate the deal. And so the earnest money deposit partner also has, signed by the earnest money deposit partner, a termination of the purchase and sale agreement contract. And once he knows that the deal is being terminated, he is sending that termination into all the parties that need to be notified of the termination, and the deal ends. And everybody gets their money back, and everybody moves on. And here's the thing, and this is how it works with me as the escrow agent. If I don't get written notification from either party as to what needs to be done before the end of the inspection period, I am killing that deal. I am terminating that contract. I don't want the earnest money deposit partners' funds to ever go hard. They are not allowed to go hard. And so therefore, if I have not been instructed by the parties as to what happens before the end of the effective date, before the end of the inspection period, I'm terminating the contract. I'm getting the earnest money deposit partner his money back. No questions asked, just, hey, this is written in my agreement. This is what I'm supposed to do as the escrow agent. I don't want to mess around with anyone's money going hard without having been given direction from either of the parties. Okay? So, let's kind of do a little bit of a review here when we think about what are the essential elements that we need to make this happen. We need two partners. We need people that understand this business and understand how this process works. And what I do is I have what I like to say my stable of earnest money deposit partners who are willing to step up to do this. Now remember, there's a cost involved. To get that partner into the deal, you've got to pay what essentially is the equivalent of hard money rates. It's 12% and 2 points. And that money is that money is paid up front, and it's typically for a 30 to 60 day period, and after that, they get their money back. That's it. So the other thing is you've got to have an escrow agent, somebody that understands the process, that understands how this whole thing works, and who is going to be able to process the whole flow of the acquisition of the property. In other words, an escrow agent that understands the purchase and sale agreement, that is willing to take on that obligation, and that acts as a fiduciary between the two parties. That's in my situation with my students, that tends to be me. I mean, I understand the purchase and sale agreement better than anybody. I've written it, and I understand the flow of the process, and both parties are, clients of mine, and they tend to be friends of mine. So we are all talking on a regular basis. So I tend to be the escrow agent for most of it. The other essential element is the source of the funds. That has to be. Now, when I say source of the funds, I actually mean it two different ways. Where is the money coming from? The earnest money deposit partner, but more importantly, where is the money being held? Now, what we try to do is we try to write the purchase and sale agreement so that I hold the money. In my client funds account for my law firm, we hold the money. We want to control that feature for our earnest money deposit partner. The people, sometimes it has to be with the title company, but it will never be with the seller's agent. It will never be with the broker. It will never be with the seller's attorney. It's either in the title company or it's in our account. So that's what I mean by the source of funds. Now, the other thing that we're going to need is we're going to need parties that totally understand the purchase and sale agreement. Because we need to understand what the flow is. Is it a 30-day inspection period, 45 days? Where is the money being held? When does the effective date begin? Have we received everything? Let me see the due diligence timeline, critical dates timeline, so that we know that we're on track here. This is the type of stuff that all parties need to understand in the purchase and sale agreement. And then finally, what is very important are properly drafted documents. Now, the people that are purchasing a copy of this program on the internet, you have these documents to be able to be downloaded. Templates of these documents. Have your attorney review them, okay? Always make sure they're reviewed by counsel. Now, I'll give you an example of what the documents are. There has to be an agreement between the partners, between the investor one and the earnest money deposit partner. There has to be the initial assignment agreement. There has to be the subsequent assignment agreement. There has to be the fee agreement so that everybody knows who's getting paid what for doing what. There has to be the escrow joiner. The escrow attorney has to agree to be joined by this contract, and then there has to be the termination of the purchase and sale agreement document. That has to be signed as well. When we do that subsequent assignment, we also have the earnest money deposit partner sign the termination letter. And so once he signs that termination letter, then that gets held in escrow as well. So remember what happens, the escrow agent has to know whether to release the subsequent assignment agreement or whether he sends out the termination of the purchase and sale agreement letter. And all of those documents are provided for you just as the templates, and that should help you get started on doing this. Now, if you need help doing it, that's what the owner form is for. If you have any questions about this, just drop me a line, info@multifamilyinvestingacademy.com, and I can help you walk you through how the process works. Don't be, oh, I forgot to tell you the punchline. So you know this guy I told you about at the beginning of the story, beginning of the presentation, that said he stole all my documents? Well, that was several years ago. A few months ago, one of my students needed to use him for earnest money. This guy, they needed like $200,000, and in my programs, we only go up to 50. This guy needs $200,000. He calls up this guy and says, "Hey, how much would it cost for earnest money deposit funds for $200,000?" And let me tell you something, folks. This guy was like at $25,000. I said, "Are you kidding me? You're going to pay $25,000 for the use of $200,000 for like 30 days, maybe 60 days?" So I called this guy in California. I said, "Is that right? Are you really charging that kind of money?" Yeah, that's right. I said, how do you do that? How can you justify that? He goes, "Well, I've lost money in this earnest money deposit program that I have." I said, "You've lost money? How the hell do you lose money in this program? If you do everything right, you're okay." He goes, "Well, there was a problem, and we didn't do this, and we should have done that. And the next thing I know, the money is being called hard. It's being held by the court. It's now going into litigation. Blah 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 blah." And I'm like, "Are you kidding me? You got in this business and you didn't understand how this operates?" "Well, I thought we were doing the right thing." Like, "Oh, you know what, pal? You deserve to lose that money. If you had understood, maybe if you had stuck with me and let me handle it for you, you wouldn't be in the situation. But I can tell you, you made a huge mistake. If you do this correctly and you understand what you're doing, this is a riskless proposition. There's always risk involved for different scenarios. But if you don't do it the right way and you proceed forward incorrectly, you could put the earnest money deposit partner's funds at risk. And if you are the earnest money deposit fund partner, don't be foolish. Be smart about your money. Understand where it's going. It's a great way to make 12% in 2 points, but it has to be done correctly. Don't make the mistake. So, all right, I'm going to open it up for questions right now. I'm going to stop the recording as we do the questions. For those of you listening at home, you can just send me an email, as I said before. But otherwise, let's wrap this up and get ready for question and answers.